the May 10th meeting of the Law, Buildings and Codes Committee to take up proposed laws, local law H, in local law I of 2021. We'll start the meeting with taking public comments, okay? And be limited to 3 minutes each. So you can, some of the letters that come in are talking about a lot of them, all 4 of them, okay? If you're speaking tonight, you're going to be limited to H and I, okay? So we will start with public comment. If you want to do that, Madam Clerk. Oh, first of
Yes,
all.
Mr. Chair, the first person that I have signed up.
Sorry, first of all, I better call to tell the members that are here. Members of the committee, Michael Bryan, Sonia Frederick, myself, and I think that's all I see. Oh, Jenny Farrell. Okay. Okay, so the full committee is present. So we'll start with the public comment. Thank you.
Absolutely. The first person that I have signed up is Marshall Miller.
Hello. Good evening. So first of all, thank you for this meeting. Really appreciate the opportunity to talk about this, particularly separating out the ROPs from good cause, because I feel like the ROPs has a lot of opportunity for improvement. And in particular, there's so many ways in which we could all work on this together. So I thank you for the opportunity for public comment right at the top of the meeting. Sorry, I'm a little out of breath. I wasn't necessarily expecting to speak right away, but here we go. Here are my 5 concrete proposals that I'd love for you all to sort of think about and consider tonight. One that's super important to me and a lot of landlords, and I should say I'm an 18-year resident of Albany. I live in on Elm Street. So I would encourage you to remove the requirement currently proposed to post ROPs on the walls of buildings. I do not think this is necessary. I think it is a real challenge for the privacy of landlords and also the privacy of emergency contacts that you're asking people to have. I think this information can be transmitted in other ways. So it's very easy to have a transfer of contact information between landlord and tenant, much in the same way the landlords and tenants pass along information around lead disclosure laws. So you have accountability from the tenant as to whether or not the landlord gave them their contact information. You also have it on file at City Hall as part of the ROP process. I think those 2 things are enough. You don't need to hang them on the wall. If you're going to push forward and still feel like this is really important, then at the very least, I would encourage an exemption for smaller landlords as opposed to big corporate ones or ones that are out of area or LLCs or ones where it may otherwise be difficult to find that contact information. But otherwise, it just becomes a really tricky issue of privacy to have the level of detail on the wall when in fact, the tenants are the ones that need to know it, not everyone.
1 minute remaining.
I would also encourage you to just think through the process of onboarding all the buildings that currently do not have ROPs. And this could be sending out a letter to all property owners. It could be including something in the water bill. It could be something that the mayor announces that as part of this initiative you feel like is really important. And I'm well aware that given the sheer number of buildings that don't yet have ROPs, this may mean more burden on the BRC staff. And I think one way to alleviate that would be to have a self-reporting system in place for buildings that consistently have had their ROPs improved and in place. So that could be the landlord filling out a form. It could be filming and saying, okay, here are the smoke detectors and how they work. I think that would make things easier in both directions, where you could get the information you need that shows that these that the safety measures like smoke detectors and carbon monoxide detectors are in place without needing any more staff time, and focusing on the staff time on the buildings that are truly problems, as well as the ones that don't yet have ROPs. So I look forward to this discussion. I'm happy for it tonight. I'm welcome of what other people have to say, and I thank you for your time.
Adrian Hill.
Can you hear me? Hey, good evening. I'm here to speak to you in reference to local law G. Just going to read it from my statement. You can stop me when my time is up.
I'm sorry, Mr. Hill. At the beginning of the meeting, the chair discussed that we were only going to take public comments for H and I tonight because those are the two pieces of legislation that's being discussed. So if you have a comment specific to
which ones are H and I? Can you just give me which ones are H and I?
JR, you want to take? One surrounds the ROPs that are required.
That's I. And H has to do with
Code enforcement.
code enforcement.
Okay, that's the one that I'm responding to. That's the one that where the codes building manager is given the right in emergencies to act. Is that the one?
Yes.
Okay, that's the one I want to speak in reference to. Okay, urban blight is a complex term with multiple dimensions. For the purpose of my testimony, I'm going to focus on three which are very prevalent in this community: substandard housing, which refers to residential spaces with structural and other physical deficiencies that do not meet health and safety requirements, thereby endangering health and safety of residents. Abandoned buildings refer to unoccupied homes or other properties that are in disrepair and pose a hazard to the health and well-being of the community. Vacant lots reference to neglected and empty parcels of land in the neighborhood that are used for dumping litter and other waste materials. The quality of our lives is highly contingent on our environment and where we live, what condition it's in, and what does our surrounding neighborhoods look like. There are approximately 2,100, 1,030 residential properties in the city of Albany. And from my estimation, close to a third of them could be deemed unsafe and unfit and fall under either of the categories that I just talked about. Housing quality and stability are a persistent challenge for low-income renters in the city, and many times they face conditions that are not healthy. And on some blocks, there are more buildings with red X's on them than homes occupied by people. Code enforcement has a clear and specific mission: keeping homes, neighborhoods, and residents safe and healthy by encouraging the repair or rehabilitation of distressed properties, ensuring vacant lots are clean, holding landlords accountable, and protecting low-income tenants and renters. This money was given to the city of Albany through the City Rise program to address our needs in this community very innovatively. I have worked with some folks who the mayor has brought on with some of the City Rise money, the community housing advocate that's at 200 Henry Johnson Boulevard, and some of the people at City Hall who have, I'm the community organizer for United Tenants. And I do a lot
30 seconds.
I do a lot of arbitration between tenants and landlords. This is a vital piece to keep our job moving in a direction where we can constantly confer with city government to help people stay in their residences. Thank you.
Deborah Pusateri.
Yes, good evening. How are you? Thank you for your time. Just a couple of ththings I wanted to. Thank you so much. I appreciate your time tonight. Just a few things I wanted to point out. For the local law H, I believe, issue of notices, you have, it appears, the way I'm reading this, that no longer must an owner get a certified mail notice if there's a problem. It looks like you're either going to deliver a copy to the person or persons in violation, which could just be a contractor, or a certified mail to the most current address on file. I would ask, please, that you would reconsider that, because at many times, I don't get communications that are left with people working on my building. It's just the nature of the beast. So in all the notice of violation or stop work order, I would ask that you please reconsider and do due diligence in notifying the building owner, because if our goal is to make things better, that's not going to help. I own a lot on Clinton Avenue. It's hard to get workers that are responsible. And it's also, you know, you have tenants that might get the notice, they might let you know, they might not. So I would ask, if you truly want to make it a better scenario, that you would do your due diligence and certify the last known address for the owner. Thank you for that. The other thing I would ask for ROPs, the increase from $50 to $75 plus increasing or decreasing the time period, that adds up to a hefty amount. You're also proposing or a change of tenants. Again, I own a low-income area and I work with a lot of challenges. I could be in and out of a tenant 3 times in a year due to the nature of, I take a lot of people in that are going through rehab. So it's challenging. And I would ask that you reconsider that, because as I look through this, it looks like the grant for the ROPs anyway, the grant has resulted in a compilation of massive amounts of fees and fines and slap you on the wrist things to fee the owner to death. I don't see anything in this that works with the property owner to say, hey, what can we do as a team to make this better? It's just, no, you're bad. No, you're bad. You gotta pay this fine. You gotta pay this fee. And to that, I just want to share that Friday, I waited for a code officer, and you know what? It's okay. It happens. I make mistakes. We all make mistakes. We're busy.
15 seconds remaining.
But this inspector was over 30 minutes late, and I had to call and ask where they were. They made a mistake. Yet you folks want to fine me if I'm 15 minutes late. Not okay. We need to work together and stop treating property owners like we are bad people. We are your partners. So I ask with all respect, stop treating us badly, stop feeing and fining us to death, work with us and put us on a panel that you didn't do with us to come up with a solution. You worked with the Rebecca Gerard from the tenant groups, but you didn't work with landlords. That's not the way to make the city better. Thank you for your time. Have a great day.
Felton McLaughlin. Vincent Ragusa.
Good evening, everyone. I was going to talk tonight. Danielle, the city clerk, told me that this was for local law H, and I was actually going to talk on local law F. But I see that local law F is going to be discussed on May 13th. And so I'll hold my comments. And the reason I was going to talk on local law F, if you remember the last meeting that we had, I did not get to talk. And when I was notified, I had left the meeting. So at this time, I want to ask your forgiveness, and I will talk on local law F on the 13th of May. Is that okay, City Clerk?
Absolutely fine with me, as long as the chair's fine with it.
Always nice to hear from you, Mr. Ragusa.
Thank you very much, Joe. So I'll talk on my part on the 13th, okay?
Great, thank you.
I appreciate that. Thank you very much.
Karen Wentz.
Thank you. Thank you, council members, for taking the time to listen. I appreciate your time. So I just want to speak as a member of CADARPA, which is a Capital District Association for rental property owners, in that we are opposed to local law I. As small independent landlords, a group of small independent landlords, we're opposed to being forced to display our personal information in publicly accessible spaces due to privacy concerns, security concerns, identity theft concerns. The new ROP posting requirements is prejudicial and discriminatory against institutional entities that can readily post place of business information and not personal information. Tenants and building departments already have contact information for their landlords and don't need government overreach to help manage their communications. Additionally, any added increases in cost for small independent landlords like ourselves must be passed along to tenants and thus result in increases in rent, which adversely affect our tenants. Stop fee and fining landlords and work as in an effort, a team effort with landlords. Also, this proposed law penalizes responsible landlords and property owners like ourselves who already do the right things for our tenants. The city's focus should be on the habitually irresponsible landlords and not and the bad actors, and not the landlords who do the proper thing and have all their ROPs in place. So every responsible landlord, by extension of our tenant, will be negatively impacted. And we ask you to think of that. The city is also requested to share, if you would, any public data that you have that's being used to determine that there is a need for these proposed law changes, because we're actually stumped as to why these are urgently needed and seem to be being pushed through with a sense of dire urgency. So we would like to know if there is any resource or source of data
30
and
seconds
that
remaining.
can be analyzed or given to landlords, sorry for the dogs, that you could currently share with us. And this is what happens when you Zoom at home. So with that, I would say thank you very much, Council, for your time. Apologize for the dogs.
Todd Drake.
Not here.
Roger Markovics.
Not here either.
But I do see Mr. John O'Grady.
Okay, I'm with Housing for All, as is Adrian. Want to speak on the posting issue first. I agree with Marshall's final comments about, I think, a good way of protecting smaller landlords is to put a sign up somewhere in the building saying, tenants, you have a right to the following information: emergency contacts, places to go if you think your rights are being violated, that sort of thing. I think we can work with the landlords on that issue. I think in general, we can work with landlords on a lot of these things, and I think we need more opportunities for representatives of both sides to sit together. I absolutely agree with Debbie and with Karen. Most of the landlords in the city are fine. Most of the tenants in the city are fine. These laws are aimed at bad actors. It does seem to the landlords, I guess, that the law is too much aimed, kind of like pulls in too many good actors also. I think where we come from is that the people who by nature don't have the power at this time are tenants. And we want to give them a little bit of a leg up when they're dealing with bad landlords. That's why the postings, that's why the emergency fixing. I've known families who have been evicted just, all of a sudden because they couldn't find the owner to fix the building. So that's my 2 points would be, let's have each side talk to each other, and let's, I guess that's the main one. Thank you.
I believe I see Felton with us that signed up, Felton McLaughlin. While we wait,
Hi, can you hear me?
yeah,
Hey, sorry about that. I've had to log on my phone. All these code enforcement requirements that that are being proposed, and there have been comments I hear on your 90 that the majority of landlords are abiding by these. Is the bad actors you got to go after. Look, more code enforcement, I think, works in everybody's best interest. I mean, many of these issues that that seem to be what we keep hearing about predatory landlords or landlords that are allowing their properties to go into disrepair, that hurts everyone. And so me personally, I don't have an issue with with greater oversight on code enforcement. I think that improves the housing stock for everyone. What is really destructive is the local law F. And I know this isn't about that about that law, but the whole good cause eviction is a bad name for it. It really is
We can talk about that on Thursday night, okay?
Okay, well, that's the one that I'm objecting to. So I've said my piece.
Thank you, sir.
Mr. Chair, I have Todd Drake that signed up to speak on local laws H and I. Todd Drake.
That's good. Is he here?
I don't see Todd Drake, and I don't see Matthew Moulin, who was the other one that I had signed up to speak on local laws H and I.
Okay. If there's no more speakers present.
I have some written comments, if you'd like me to share those.
Yes, would you, and try to limit what you can to H and I?
Yes, Mr. Chair. Dear council members, and especially the law committee, and this one is from Miriam J. Tell of 354 Delaware Ave. She supports all of the legislation, F, G, H, and I. Notice and enforcement of code violation and changes to ROP, which gives the power to the building to the building department to act in emergencies. In my professional life, I've worked in the affordable housing and community development world for over 20 years, covering these topics nationally. So I have good context for how important they are, and the fact that they work, as well as deep respect for the expertise of the folks that helped Albany develop these suggestions. They are good policies that will help stabilize both families and buildings, leading to stronger neighborhoods and a stronger city. Please do not be scared by landlords claiming the world will fall apart with this. It won't. However, it is true that many smaller local landlords have been hurt by the pandemic economic crash, as their tenants have been. We should use recovery money to target relief to these landlords, and we should look ahead to programs to help smaller landlords bring their buildings up to code in exchange for keeping their units affordable going forward. In the meantime, modernizing our code enforcement and strengthening our tenant protections is essential as we head into a time that is likely to involve a lot of housing court activity and building turnover. The city will be grateful to have acted now, not later, on these matters. This one is from Thomas Vandor of 50 Twiller Street. I am opposed to local law I. One, as a small independent landlord, I am opposed to being forced to display my personal information and the personal information of emergency backup people who might be private friends or family members in publicly accessible spaces due to privacy concerns, security concerns, and identity theft concerns. The new ROP posting requirement is prejudicial and discriminatory against small mom and pop landlords who are not corporations or institutional entities that can readily post place of business information and not personal information. Tenants in the building department already have contact information for their landlords and don't need government overreach to help manage their communications. Any added regulatory cost for small independent landlords must be passed along to tenants and thus results in increases in rent, which adversely affects our tenants. This proposed law penalizes responsible landlords and property owners like me who already do right by our tenants. The city's focus should be on habitually irresponsible landlords and bad actors who do not have ROPs, not on landlords who do have ROPs. Every responsible landlord, and by extension, our tenants, will be negatively impacted. The City of Albany is requested to share publicly all of the data that has been used to determine that there is a need for the proposed changes to the law. The city also should share the sources of the data and who analyzed the data and suggested that the current laws are insufficient in their existing format. Please advise where this information located is for public to review. Speaking to subsection 231-135-B2, the proposed 14-day and 30-day times from date of mailing do not provide sufficient time for small mom and pop landlords to fix issues that may be cited. For urgent issues, the notion that 14 days are actually being provided to fix a problem is misleading, because the property owner will not have received the notice for a considerable period of time after the mailing. Consider a mailing on a Friday before a 3-day weekend containing a federal holiday. The post office might not even deliver the mailing to the recipient before a full week has passed, thus giving maybe 7 days to address a concern. That is impossible in the real world, where contractors may not even be able to respond in time for work that may need to be performed. The proposed ROP posting also contains prejudicial language that creates an adversarial relationship between tenants and landlords, especially with the requirement for property owners to include language and information that is not in the best interest of the property owner, but rather in the best interest of third-party entities and advocacy groups and organizations that are not a party to the landlord-tenant relationship. This one is from Maria Markovics, who's the co-chair for Housing for All. Housing for All strongly supports the proposed changes to the residential occupancy permit detailed in Local Law I of 2021. Unfortunately, many rental units in the city of Albany do not have the required ROPs because some landlords have ignored the requirements with little or no penalty. The result has been bad for the tenants who move into these apartments and for the neighborhoods that continue to be impacted by the deteriorating housing stock. We believe that having the ROPs posted in the buildings with the names of the owner and person authorized to act in an emergency with the necessary contact information is an important step toward holding owners accountable and ensuring that the ROP process is open. Tenants will know whether the apartment they are considering occupying meets all safety standards. We understand that some owner, occupant, and small neighborhood landlords have expressed concern about having this information displayed openly, particularly if the emergency contact is a relative. In response to this concern, there was a recommendation that for owner occupant landlords and small local landlords with less than 10 units, excluding LLCs, the necessary ROP information could be given to tenants as a lease addendum, or if no lease, then in a folder. However, there must be a notice publicly displayed stating that tenants must be in possession of the required ROP information. How are we on time? Mr. Chair, can I continue? We have about 4 more written comments. The next one is from Betty Ann Benware. I am opposed to Local Law I. As a small independent landlord, I am opposed to being forced to display my personal information and the personal information of emergency backup people who might be private friends or family in publicly accessible spaces due to privacy concerns, security concerns, and identity theft. The new ROP posting requirement is prejudicial and discriminatory against small mom and pop landlords who are not corporations or institutional entities that can readily post place of business information and not personal information. Tenants in the building department already have contact information for their landlords and don't need government overreach to help manage their communications. Any added regulatory costs for small independent landlords must be placed along to tenants and thus results in increases in rent, which adversely affects our tenants. This proposed law penalizes responsible landlords and property owners like me who already do right by our tenants. The city's focus should be on habitually irresponsible landlords and bad actors who do not have ROPs, not on landlords who do have ROPs. Every responsible landlord, and by extension, our tenants, will be negatively impacted. The City of Albany is requested to share publicly all of the data that has been used to determine that there is a need for the proposed changes to the law. The city also should share the sources of the data and who analyzed the data and suggested that the current laws are insufficient in their existing format. Please advise where this information is located for the public to review. I'm speaking to subsection 231-135-B2. The proposed 14-day and 30-day times from date of mailing do not provide sufficient time for small mom and pop landlords to fix issues that may be cited. For urgent issues, the notion that 14 days are actually being provided to fix a problem is misleading. The next comment is from
Todd
Steve.
Drake, who's here, who was called earlier.
Todd Drake is with us.
Yes.
All right, Todd Drake is.
Hi, thank you. I know there's been a lot of comments. I'll be very brief. With respect to posting of personal information or even company information, I'm not sure where the impetus comes from, and I would like to see, how this came about. Every property is leased to a renter, and all that information is provided at the time of lease. Quite frankly, if somebody is contacting the company or the individual who owns their rental unit for assistance or for payment or for whatever, it would be absurd to suggest that the average renter doesn't have contact information for the person that they rented it from. If there's a legitimate agreement and financial relationship, there would have to be contact information. I don't understand where this comes from. With respect to posting things on the building, I don't see why that would be necessary, because the city has a database of all of these things. And in today's day and age, it could easily be mobile for inspectors who would benefit from that information. And I think that really shouldn't be on the property owner to put forward. I think that would be on the city to maintain an appropriate database for its staff, which is important. As the comments that were just read, the people who are responding here are those who are doing the right thing, and we don't understand why all of this would be necessary. Also, just with respect to timelines and repairs, and all of these things are important. Everybody wants everything fixed. I will tell you though, I've received letters from December in March asking things to be fixed from the city. And again, I think it's a two-way street. I think good communication solves these problems, not legislation. And the last thing is that many proponents of all of the proposed local laws are suggesting that there are no recourse for renters or neighbors to request that problem properties be addressed, but that's simply untrue. Anybody who's contacted Mr. LaJoy or anybody else in code knows that they are responsive and have certain remedies already available to them under existing law. So it seems like a lot of these new laws are very duplicative, some of which were dramatically reinforced under the 2019 Housing and Tenant Stabilization Law. So I feel like we're reinventing the wheel without need to do so, and that these remedies are available at present.
Thank you, sir.
So, Mr. Chair, we have 3 more written comments. John Parody of 385 McCormick Road, Albany, New York, repeats Betty and Ben Ware's comment verbatim, as does Sean D. of 52 McElwain, Cohoes, New York, and I've already read those comments for the record. Steve Tenderwicks of 13 Myrtle Ave has a comment which reads as follows. I'm writing to the council. As a taxpayer and landlord, I am against the proposed ROP changes. I've been a landlord for many years in the city. I think ROP changes will really be a hit against small landlords who are readily available to most tenants anyway. The changes also do nothing to deal with the irresponsible landlords and those without ROPs. As you know, there are a considerable number of bad landlords throughout the city who this won't really apply to. They will continue to act illegally and evict who they please and not respond to tenants who live in their buildings. I live in the South End, and there are plenty of landlords who won't comply, and the city will do zilch. The city needs to rethink the approach and come up with better solutions. Thank you. And that was Steve Tenowitz. And that's all that I have. I'm not sure if John Raphael has.
Well, no new ones, okay? If they weren't signed up, or they have to come back next week. At this time, I just want to make known the members that have showed up at the meeting. We're here before: Richard Conti, Kathy Fahey, Judy Doche, Kelly Kimbrough, Alfredo Ballerin, and I think that is it. So at this time, I want to move on to sponsor.
Joe, it's Tom Howie. I'm here also. Thank
Okay,
you.
Tom, sorry, I didn't see you there. Saw you a second ago in the car the other way. So if we go with, start off with Local H being sponsored by Councilman Anane Owusu.
Yes. How you doing, Chair? I hope everyone is doing well. And first of all, I just want to thank the public for their feedback on all of the legislation. So my bill more so deals with unsafe, unfit properties. This proposal supports buildings department ability to stop illegal building work that present immediate health and safety threat to residents who live in the vicinity of the building. This legislation also allows building and codes to place responsibility on owners of these buildings for the cost of repairs made by city workers to address illegal work or egregious failures to maintain buildings, which often requires a response from multiple city departments. Ultimately, this legislation helps tenants and benefit neighborhoods by reducing displacement of tenants from unsafe buildings and who are often left with no other option but to stay at a homeless shelter or in some other emergency housing. This legislation further helps stem the abandonment of buildings in our neighborhoods. Quite frankly, and the mayor said it, and many of my colleagues who were at the press conference a couple of months ago said it, inaction is not a choice. Our community needs all property owners, and especially financial institutions, to take a proactive role to ensure that these properties are taken care of. And if that's not possible, they should sell it to someone who will take the responsibility of owning the property. A couple of months ago, during the height of the pandemic, I had an instance, particularly in my district, personal, I actually had to assist that tenant with making sure that they found an emergency shelter place where a landlord was having dispute with the tenant, and the tenant was actually paying rent for 12 months straight. No issue. All of a sudden, the landlord just wanted the tenant out. A couple of weeks later, all of a sudden, there's an emergency with the boiler. There's an emergency. And the landlord, in my opinion, I believe, used that as a tool to evict the tenants. And that is not right. And that's why I support this legislation, because again, if the landlord, and I think also this benefits the property owners, if they don't have the financial means to fix the property, the city with the RISE grant, we want to thank the Attorney General for this major contribution, is going to use that money to fix that property and bill the property owner in the back end. This is a benefit to property owners and also a benefit to the tenants. And I strongly believe, while we have all these legislation, these housing packages, housing is a human right. And I strongly believe that property owners and tenants should have the same responsibility to the property and stake into the property. A property owner cannot just destroy their property and attempt to evict a tenant. And I witnessed this a couple of months ago with a constituent of mine. And when I reached out to Building and Codes and also with the administration, we had to do something about it. I know change is hard, but ultimately, government officials, we must act on the behalf of the residents of our city. We have to help individuals help themselves. And that's what I fundamentally believe the role of government is. And that is what this legislation is going to do. Thank you.
Also, now, I'd like to start off give the floor next to all members of the committee first, and then go on to other council members. So anyone on the committee? Mike O'Brien? Unmute.
Yeah, I liked John O'Grady's proposal. And he said that he also works with Adrian Hill at United Tenants. And he suggested some sort of an informal working group of property owners and tenants, which I think is probably a good idea. I don't know how to incorporate it. This is more with, this is more with the RO. Well, I guess it could apply to both H and I, but I like that idea. I think it has some merit. I don't know how to incorporate it in. Maybe John has some suggestions on that. I know in other aspects of city government, we have a number of advisory panels that are composed of, consumers of services and providers of services. And that seems to me like a good idea that maybe could avoid some of the, and avoid going to the enforcement stages, which is a savings to everybody. And then the other point on the ROP legislation.
Staying with H right now, okay?
Oh, we're just on, okay. Well, that's my comment with regard to H.
Okay. Anybody else? Committee members? No. Sonia? Fredo? Nobody right now? Okay. Wow. Alfredo, you raising your hand? Okay, unmute yourself. Alfredo. Alfredo, I can't hear anything. You don't have your setup, your sound?
Can you hear me now?
Yes, now we can.
Okay, I'm sorry. I'm having technical issues. I guess two things. One, I think it's important for us to be able to have who address these issues and be able to have them corrected and give the owners the time, I think 14 days in legislation to correct it. Some of these issues, when you just leave it, they don't get corrected, and that's the problem. You can fine a person for not correcting the issue, but that doesn't correct the issue. And sometimes the fine is less than the cost to make the repair. And by not making the repair, you really create a situation where you have tenants that are not in a substantial situation. So I think it's important that property owners know that you've got to fix your properties. I mean, there's just no question about it. If you're gonna have people live in these properties, if you're gonna rent them out, you've got to maintain them. And I'm okay with the suggestion that the property owner should also get a notice. I'm okay with that. But I think we really got to stick to making sure that code has the authority to go in there and make these repairs if they're not dealt with in a timely manner. I mean, these are safety issues for the individuals that are living there, and it's also about the neighborhood. How do these violations affect the neighborhood that we're all trying to improve? So I support it. I'm okay with some of the suggestions that were said by some of the speakers to try to address it and try to make it so that the owners get notification as well. I mean, I think folks are already doing that. So I would support that and make sure we have the resources so that it can be done, properly.
Okay. Any other committee members? I don't see any hands up. Back to the sponsor. Go ahead. Or so you want to tie it up?
Yeah, I would just like to make a motion to move it out of committee with a favorable
I'm
recommendation.
sorry, Mr. Chair. I believe Councilmember Conti had his hand up as if he wanted to ask a question before the motion.
Hold on a second, Wilson. Go ahead, Richard.
Yeah, I was using the raised hand function, which I thought was the way should be doing it. I'm sorry. Maybe I should just blur it out. I did have a question though. I mean, one of the issues, and I see Judy also has her hand up. One of the questions or issues came up during public comment was the form of notification and the use of certified mail versus regular mail, I guess, or et cetera. And I gather previously was done by certified mail. Is there a reason why? And maybe Rick or Rob can address that issue. The using certified mail is the appropriate form of notices of violation to the owner versus other forms.
Yeah, it was the intent to continue using certified mail, just to open up the number or the addresses that certified mail could go to. I think there was a drafting error, specifically just referring to 133A-2B subsections. Sorry, it's like a. Yeah, if you look at subsection B there, it does say certified mail for each, type of address. It should have said that under 133A-2A as well. I'm not sure how that slipped through the cracks, but it was always the intent to send it by certified mail.
So that would be need an amendment for that.
Yeah.
Okay. I had another question, and this relates to actually a question that Judy had raised in one of her emails to you, which I believe all members were copied on, and then you did the follow-up memo, which I believe all members received. This was on local law H. And the question was regarding the building department's authority under chapter 20, which I think there is some confusion there, and which led me to remember, which I have language that every now and then I find as I go through my papers. When we were doing the USDO back in 2017, in addition to the actual USDO chapter 375, there were a whole bunch of wraparound amendments in that ordinance. There was about 30 or 40 pages of amendments that were never really discussed in committee, but Dave Gonzalez and I at the time worked on revising that. Some things fell out. One of the items that fell out were amendments to chapter 20, basically to move the chapter 20 provisions over to chapter 42. So it'd all be consolidated and do some updating. Is this the same issue that I think Judy is raising that you referenced in that memo? Because I have
a little bit. Yeah, I mean, we're trying to address the fact that there are just numerous and various delegations of authority to the building department. And we were trying to consolidate at least the notice of violation process to capture all of those.
So I have that language, which I believe was, also supposed to, I think some of the cross references in the USDO are incorrect because we didn't do that. And I only have hard copy of the language, which I meant to try to, put together as far as at some point, but it's been sitting with me since 2017. Does it make sense then to try to incorporate this into local law H and get it all done? Otherwise, this is just going to sit for another 4 or 5 years.
I haven't seen that language, but a lot of this is housekeeping. If that's another item we can add.
Yeah, it was Dave. It's not drafted properly, but it was something that Dave Gonzalez had put together at the time. As I say, I only have the hard copy for whatever reason, and
Okay.
But it might make sense to look at that and to see if it can be incorporated into a local H.
Yeah, that sounds like a good idea. So I can look for it on my end, but I'll reach out if I'm unable.
And I'll see if I can somehow either maybe drop it off tomorrow. I can run down or something like that.
Okay, great.
Okay, Judy Duche is next. That's it with you, Richard. Any more?
No.
Thank you. Judy?
So that's helpful. And I just want to say that periodically administration members talk to me, members of Corporation Counsel's office talk to me about how we have so many provisions in our code, in the city code, that are just inconsistent with one another or completely archaic. We could probably, go through an entire list like that. And I'm glad to hear that you're going to take a look at this, because I'm really uncomfortable with working on one piece of legislation that is assigning certain responsibilities to the chief building official without referencing where that position is created, number one. And maybe, that already exists someplace in chapter 133 or 133. Well, it wouldn't be in 133A. And having some of those responsibilities be directly in conflict with a commissioner of buildings. And I think that, this has been somewhat an issue of debate for about 8 years, whether or not there's going to be a commissioner of buildings. I think that it's time to bite the bullet and just say, if there's not going to be a commissioner of buildings, then let's eliminate all of the language associated with that. I note that Richard Conti's local law that we're not discussing tonight does take care of that, eliminating a reference to a commissioner of buildings. So I would prefer to see, as long as we're tinkering with so much of these statutes at the moment, I would love to see all of that cleared up at this point. I had noted in my email, and Rob, you indicated, so one of the things that happens with the drafting in this legislation is, in some cases, it's referring to the housing code. Some places it's referring to a violation of this code, a violation of all notices issued pursuant to chapter 133 or 231. In another place, it refers to the Uniform Fire Prevention and Building Code, other laws. This code then doesn't mention the USDO there. Unless there's a real intent to mean something different in each one of these places, I think that it creates a lot of ambiguity and a lot of confusion. And I would like some terminology just to be used consistently, so that, maybe there's a place where you add a definition, for this particular article. When we refer to all provisions of this code, we mean USDO, this, that, and that, and everything, and list everything that the commissioner is responsible for enforcing in this. Let me see. And I noted that in the scope, chapter 231 had been deleted in the scope, and you said that that was just a drafting error, so that needs to be addressed before this is passed out of committee, or needs to be noted as an amendment. And then I also had in with regard to 133A-2B, I noted that there were some of these same shorthand kinds of uses that you agreed added to some ambiguity. So those are just some drafting issues that I think need to be addressed. And otherwise, I didn't really notice anything. There's also section 3 refers to this ordinance shall take effect. And I think it needs to say local law, because I understand that probably in an earlier draft, this was an ordinance, and now it's a local, and now it is a local law. So those are my comments on this.
Rob, about the question, the ambiguity of the commissioner and the building.
Okay.
Yeah, so the update uses the term chief building official, which is meant, as I understand it, to be applied without reference to a specific title. So it could apply to a commissioner or a director or whatever the name of the head of the building department is. So that's why that term was used. And that is also the term that's used in the USDO.
So is there a way of clarifying that so people reading this doesn't have the same questions that just arose? By a definition, maybe, like as Judy said?
Yeah, we could do something like that.
I don't want to see this legislation being held up for a period of time and over this issue. That's all.
Yeah, that's an easy fix. There may even be a definition in the USDO already that could just be incorporated.
Are there any other council members now, or committee members first?
Yes.
Mr. Hoey?
Yes. And thank you for letting me speak. By the way, I didn't get notice of this meeting today. I had a hard time getting in with Zoom. I mean, I could have gotten in through Facebook, so I'm a little bit tense on that. But, you know, I agree with Councilman O'Brien that there should be a group put together. I've gotten more mail about these changes. I'm talking about regular mail. I've gotten dozens of cards and letters and phone calls. And people are very tense and upset. And I want to make sure before we do anything that we think this out and that we hear from all sides. And, you know, having a meeting that was very hard to get into, even for a councilman, it makes me a little bit nervous. So my feeling is that we should try to put something together like the gentleman said and Mike O'Brien brought up. Thank you.
Sonia, I didn't see your hand raised before you.
It's okay. Yep, just for all the comments being made about the various language changes and amendments. Curious to know, and I guess I'll turn to the sponsor. Are we making those changes as amended? Are you looking to vote on it today? Or are you looking to make those amendments, bring it back to the committee and then discuss further?
Just want to say thank you. And it's valid amendments and recommendations that have been put forward by Judy and also Richard Conti. And I'm okay with tabling it for further discussion and also further amendments. There's no rush as relates to that. But I also want to clear something up as it relates to communication with landlords, right? During this package that was introduced, we asked over 30 landlords to participate in discussions. Over 16 actually showed up and we had meaningful discussions. We also invited the Capital District Association of Rental Property Owners, and they actually refused. So I don't want people to think that we haven't reached out to landlords in our city. We reached out to over 30 and 16 actually showed up and were part of the discussion. And also another comment that was made earlier during public comment is that the privacy aspect of posting the ROPs. I want to just make it clear that posting the ROPs is not meant for just tenants. It's also meant for first responders in case of emergency when they attend some of these buildings and there's fire or it's just a property that needs to come down. So again, it's not just for the tenants, but it's also for first responders. And the last thing too, as it relates to the commissioner position or as a director of buildings, I support making Rick LaJoy actually the commissioner of buildings. I strongly think commissioner is the right title for, quite frankly, one of the finest staffers we have in the city of Albany. So just want to throw that out there. And thank you.
With a commensurate pay increase.
Oh, great. That, as he should, as it should. Thank you.
Okay, are there any other comments from council members on this? But also you're going to table for amendments, right? Mike?
That is correct, sir.
Okay, Mike.
Yeah, and could I also get like Bob McGee's opinion on an advisory board as suggested by a couple of the speakers, and how or should that be put into the legislation, since Bob, I believe you're the guy who's going to rework all the drafting issues that Richard and Judy brought up.
Right. Yeah, like Councilmember Nani said, we did host, I mean, all of these proposals came out of, dozens of community engagement sessions that we had as part of the Cities Rise program. But we can set up another advisory panel type situation. I'm not sure how the Common Council would like us to go about that, who we would want to invite. I haven't done this many times before, so I'm open to, your suggestion.
But I thought the way the speakers talked about it, the advisory panel would be more of an ongoing thing, not for the purpose of writing the legislation, but for the purpose of trying to facilitate on, as problems come up.
Something where they might meet biannually or quarterly or something like that, Mike?
Whatever people think the need is.
Yeah, I think it's a great idea, Mike. As long as it's not holding up the legislation, I'm all for it.
Oh, yeah, if we could get that together, at least putting what Bob thinks would be an appropriate way of including the possibility of it within the 2 weeks or whatever time it takes for us to reconsider this, which I assume would be less than a month.
No, totally. I agree, Mike, because there's other legislation that's going to be coming up. I mean, there are some of my constituents that want me to revisit the group law. I mean, there's a whole host of things. So it would be good to have landlords and community in an open discussion moving forward from now on. But yeah, thank you, Mike.
Okay, that's it for proposed local law H. Can we get on to local law I now? And can we start with the sponsor, Kathy Fahey?
Hey, thanks, Joe. So this legislation, it includes some very important updates to the residential occupancy program. And, all you have to do is, well, first I should say that we have, many responsible landlords. So everything we do here, they need to be taken into consideration. But of course, most of these parts of this legislation, it is directed at those landlords who are quote unquote bad actors. One of the most important things that it does is getting that contact information. I know that there's been many times that the administration has tried to track down landlords and with a great deal of difficulty. So putting those that essential information, a copy of the license, the social security number, the emergency contacts, if it's a corporation or an LLC, getting that EIN number, getting that information to contact these landlords is essential. And also just to address the posting the ROP, I think it's very important that that people who go into that apartment and considering renting, and the people who live there know that it is up, the codes has inspected it. It doesn't have to be, it can be a small bit of information that's posted. I think it's extremely important that people have that information. As far as the contact information, I do understand the privacy concerns, but there's got to be a way for people who need the information to get it, whether there's a phone number that they can get it from the city. I'm really open to discussion on that aspect. But as far as the actual posting that it's up to date, I think that needs to be there, and it doesn't have to be poster size. It can be something rather small, but people need to know. Now, as far as the lowering the time that they do the re-inspections from 30 to 24 months. I think that makes sense because of all the turnover that there is in rental properties. I think it's important that the city stay on top of the condition of these rental dwellings. We owe it to the tenants. And as far as changes in fees, $100 for the first time. and then subsequent ones are 50. You know, I was listening to the woman who said, well, she has tenants. Sometimes she'll have a new tenant coming in every couple months. And I do realize that, you know, I'm thinking, yes, that will get more expensive. But then I have to ask the question, why is there that kind of turnover? And I would ask, you know, I'd ask Rick and you know, how often does that happen here? Is that something that a lot of landlords experience? So I think we need to have a little more discussion on that issue. But again, these are businesses, and that does not, you know, the $100 for the first time, $50 ongoing. That would be one, you know, paying it once every 24 months when, unless there's been a change in tenancy. You know, these are businesses, and we have to, and even for the smaller landlords, I don't think that fee is too arduous. $300 for no-shows. I mean, we all know how much it costs the city to go out and do the inspection. So if people aren't showing up for the scheduled inspection, you know, there should be, they should be fined for that, in my opinion. Let's see. Oh, as far as the reminders, that's I think something that we need to discuss also. I know the director, Rick LaJoy, was saying that if people do miss the reinspection, scheduling the reinspection after the 24 months, that they will get a notice telling them that they're late, and then they have X number of days. But you know, again, I do agree that, you know, if we can, why not do some kind of an email notice? I mean, that's something that isn't costly. It is more time by the administration, but it doesn't have the cost of you know, sending out a letter. If we are going to be following it up with a letter, you know, if they haven't, if they're late. So I think we need to discuss that a little bit more. Is it something that we could do that wouldn't be too much of a hardship and cost to the city? And then the power to, this also includes power to revoke an ROP. I think that's an important power to have as far as the health and safety of our tenants. So there's a lot in here. It's long overdue, a lot of these things. I know a great deal of time has been spent by Housing for All and our administration in coming up with this new piece of legislation on our rental dwelling units and our ROP program. And I hope that we can have more discussion on this and then hopefully pass it. Thank you.
Okay. Rob, Rick, do you have any comments on these two pieces of legislation that you'd like to talk about?
I think Councilmember Fahey summed it up very well. I don't have much to add beyond that. I mean, one thing I will say about the landlord contact information being included on the RP and then posting the RP at the building is that the landlord would be able to provide whatever contact information, whatever phone number they wanted to, as long as they responded to that number when they were called. We're not asking for, you know, their home address or anything like that. I mean, just basically provide a number where you expect to receive calls from your tenants or from emergency services that we can include on the ROP. That's all that's being asked with that particular provision. And I do think it's important. I mean, in many cases that information is on file, but the reality is that, you know, the times you need it most, it's going to be off hours. The office is going to be closed. There are going to be technical difficulties accessing information and things like that. And when you need that phone number, you do genuinely need it. So that is a very important part of the changes, as far as I'm concerned.
Rick?
I appreciate everybody's, feedback, and it's certainly, none of this has been done in the closet. It's been a couple of years of a lot of community engagement with landlords and with tenants and advocacies, for both. So again, none of this was done in a vacuum or should have been a surprise to, everybody. And I believe there are still things that we can tweak and, make better and deal with. And I believe we can do those ongoing. So even if the legislation itself passed through, whether the federal ID number or whatever might have to be on the back on an ROP can physically be on the back of an ROP so that it's not everybody is looking at it, but if a first responder or somebody shows up and needs any of that information, you take the ROP off the wall and you look on the back. I mean, there's ways to address these things. The cost of somebody misspoke earlier and said the ROP was being shortened to 24 months and increasing to $75. That's incorrect. It was staying at $50. And we haven't had an increase in almost 9 years, I think, in cost, but it does cost the department quite a bit to, do all this stuff. So, this stuff was well thought out. And I think, like anything in life, we can always make it better and work upon it. So I appreciated everybody's comments and input.
Thank you, Rick. I know we've been working on this. Richard will tell us that. We've been looking at some of this for 12 years, trying to track down owners of, the abandoned houses, those with the X's on it. We sent the police out and everything else. I think we're inching closer to getting a better product. Richard, you're the next one up, and then Michael, Brian, and Sonia, I see your hands up. Richard?
Yeah, I know Sonia's a member of the committee. I don't know if you want to go with Sonia first.
Okay, go ahead. I'm sorry. Sonia?
Thank you. And thank you, Commissioner, and Mr. McGee for the clarification on the communication aspect. I do support this legislation. I do think there are some considerations that need to be done to the communication piece, particularly with the concerns about, identity theft or information. And so, I'm in support of this legislation, but if there's ways to have the template be so that certain things are shown on the front and on the back, I like that idea. Or likewise, having just the phone number, best contact, and maybe emergency contact if that comes into play on the back, something of the sort, so that people don't feel like their information is being exposed, particularly probably to people who come in and out of a home that don't necessarily live there. So, but I do support this legislation. So thank you.
Okay, Richard, back to you.
Thanks. So I have a couple of questions. And some of them is just some background information to help me understand some of the process more. I think it's important to post the ROPs so that tenants also know that the building has been inspected. So, definitely support that provision. In terms of the contact information, are we talking about the need to have a name or just a phone number is adequate as far as an emergency contact? And do first responders use that in terms of when they're responding at a building? Do they either reach out to Rick, to you, or whatever if they need contact information?
Yes, sir. Very often.
Okay.
Depending on the emergency, it could be a flood. It could be, roof is leaking and ceilings are collapsing. I mean, there's a lot of instances where FIU with the fire department and my staff need that information on hand. And, we all do not share the same database, unfortunately, within the city. So what the police department has on record is not what the fire department has, or the water department, or ourselves. So that all becomes an issue when you're standing there, after hours and don't have access to this information.
Okay, but I'm sympathetic if we can address some of the concerns that privacy concerns that people have raised, or those issues, while it's still making sure that information is readily available to those who need it. I do have a question, though. I know this came up earlier in public comment, I think by Mr. Miller, also about the issue of unregistered units and the number of unregistered units out there that we're really focusing right now on those that you might say comply with the law. So I guess, Rick, my question is, to what extent do we know the number of unregistered units, rental units that might be out there that are being rented? And what are the strategies that your department uses to try to identify and bring those into compliance? And I think one other thing that would be helpful is if there was kind of a real-time interactive database online that people can look at, neighborhood groups, others, to really check whether or not some of these units do have an ROP or not, because sometimes it's the people in the neighborhoods who probably know best who's in compliance or not. And I think you've been posting a kind of like a monthly static sheet, but it's not the same as having a real, real-time online interactive one. So those are my questions, just to try to get a better understanding of the process now. The unregistered ones, what are we doing? And getting information, timely information online that people can check to see whether some of these units are actually in compliance.
Sure. So the ROPs that are listed online, like you said, they can be a month behind depending on when that's pulled over to the city website. Internally, we are actually working with the software program that we have currently, and we are adding live online citizens portal, which will have access live time for everybody to see. So that's literally in the, as we're sitting here, I just got the quote for this stuff. I don't have a number of how many places do not currently have the ROP. I don't believe it's half. I mean, that's, kind of far-fetched to think half the city is without the ROP. However, when we did move to the new software program a couple of years ago, it did not transfer all of the information from the old database. So we've been methodically going through it. I've gone through 17,000 of myself to look and see what's going on. But we do, with building blocks, have mechanisms in place now where if a police call goes out for, say, a tenant landlord dispute, immediately my vacant building coordinator gets a tickler in his system set up that he gets an indicator that says, hey, this property had a tenant landlord dispute. We look in there, and if there was no ROP, I mean, then he checks everything within 250 feet. So we've been very aggressive, and that's just one. I mean, we are very, very aggressive with how we're going after the folks that, so to think we're doing this and not concentrating on that is, obviously false. But we are really aggressive. We're doing a lot of proactive neighborhood sweeps where we're checking all the, whatever blocks we go on, we're checking all those avenues. And then, again, we just still also rely on neighbors. And as we get called out for different calls from the fire department or police department, we're constantly checking, and then all the surrounding areas at that time, because of all the information that was missed when the new system was set up a few years ago.
Okay, great. And then the other issue that came up was the renewal notice. And right now you don't send out the renewal notice. If they don't renew, they get the letter, which some people refer to as a little threatening, but I'm wondering if there's a way, and Kathy sort of mentioned the idea of an email renewal notice, which I assume that you have emails for as part of the registrations. And if there's some way to do a renewal notice up front.
Yeah, we would definitely look into doing that. Just so you know, I would say it's about a 60-40 split. 60% of the people that apply don't have emails still.
Okay.
So, that'll be a good avenue to capture some, but it won't be enough for everybody. And I know the notice of violation going out in lieu of a reminder, scares people, but it's meant to get their attention. And as responsible owners, the burden's on them to know when they're up anyway. So we sent out a notice that gives them 35 days to register and get it scheduled, not to have them done, just to have them scheduled. So to me, 35 days is a pretty good notice. And what also, just so you're clear on what this does also, is in lieu of sending a notice and then not having somebody respond and then sending a notice that has to give them that same 35 days, you're now 60 to 90 days out before you can get a non-compliant person into court, which is not fair to the tenant, versus 35 days, I can now get somebody that's going to be non-respondent into court. So, I understand people love to have the reminders, and if we can figure out a way to do it with an email, I'm all for it. But the notice of violation is definitely the better way to go, because it gets us to be able to get someone in court that is not going to respond and to work with people that do respond. Okay. So it's not a, beat up on the landlord at all. It's really, here's your reminder. You got 35 days, and then just to get it scheduled, and you can schedule it 35 days after that, for all I care. And not to mention the staff time it takes, because all mailings have to go out, both regular mail and certified mail. It's just a lot of money to do that. And then they have to do it again with the notice of violation. So, but I am open to, figuring out if we can pull a data poll out of emails. And then once the legislations, when they are finally finished and they go through, we are going to send out a massive mailing telling the entire city, here's the changes, here's what it means, et cetera. And then ask people to also respond back to us with their good email information and stuff, and, have that opportunity to communicate with everybody in one mass mailing versus, kind of piecemeal.
Great, thanks.
Yes, sir.
Okay, going back, I have Judy, Mike O'Brien, Tom Howick, and Felton McLaughlin. I'm sorry, the public comment period is closed. You'll have to wait for the next meeting.
So I think that means I get to go. So I just, as interesting conversation about how do we get more people in compliance on the ROPs? Because really, we want everybody to be doing it so that we know that, every household that is being rented is safe for people. I was wondering if it would be helpful, and I don't want to stall this legislation for this, but if it would be just something to consider, helpful to require homeowners to include something requiring homeowners of properties that are on record of having 2 or more units to file an affidavit proactively saying if they are not actually renting out properties, the other unit, and providing that clarification to the city. And then we know to call, and maybe, have them do that kind of notice like once every 2 years. And then you have the legal authority to require essentially a yes or no, I'm renting, I'm not renting piece of property. And then whether or not you need to follow up with an ROP or not. Thoughts, Robert, Rick?
Yeah, I mean, speaking practically, I know there'd be a lot of resistance to that. But I think the administrative burden, I think Rick can speak to that, but that would be pretty significant too.
I think when I just spoke about the mass mailing that'll go out once this is all, kind of finalized, we're still working on that internally, and it could very well be a questionnaire that we ask people to fill out and return. Do you have your ROPs? When do they, just kind of verify information we do have, and then find that information that we're unaware of. So I don't think it would be a big deal to incorporate something in this mailing when we, send out something stating what the changes are, what it looks like, what it means for, new or for landlords, et cetera, to have that, those questions captured in a questionnaire. Nothing elaborate, but just, a little index card with a handful of questions that we can garner a lot of useful information that we may not currently have.
So my point being that for you to do that and have some weight to it, to actually put it in, potentially put something like that in the legislation. Otherwise, nobody has to respond, arguably, right, Rob?
Correct.
Yeah, I mean, they wouldn't respond. I know that, we did something similar to that when we implemented the waste collection fee. And, we had people swearing that they weren't using the second unit for, particular use. And you are going to get a lot of situations where people are saying, well, I'm not renting it now, or, I'm not planning to rent it for the next 6 months. Or, I mean, it's just people's intentions with respect to those second units is always in flux. And then you also find too, just tax records are often, they're not all that reliable in terms of identifying what is the second unit and what's not. I mean, you'll find a lot of genuinely single family homes that are designated as 2-family. So it is hard to even, determine based on the simple record that you have in front of you, whether or not the unit is, there is an additional unit at the building.
So has that curbside waste collection fee database been cross-checked against the ROPs? Like that would give you a pretty clear indication of who's should be registered, right?
Yes, it was. When it was first implemented, that was one of the data points we used to send out just a citywide, I mean, every unit that appeared to be, being rented, we sent out a reminder, or that didn't have an ROP, got a reminder saying that if they are in fact renting, that they should get an ROP.
Judy?
Thank you. So again, I want to note that there's some inconsistencies with regard to the references throughout this. That again, I think whatever we're doing here and whatever responsibility the chief building official in the Department of Buildings has for compliance and inspection, we should be consistent. Inspection on the second page where it's in paragraph 1, it says, which shall determine compliance with and enforce all applicable provisions of this code and the New York State Fire Prevention and Building Code. Doesn't refer to the USDO there and other applicable laws, which I think, again, when you're doing the ROP inspections, you're looking for that, right, Rick?
Judy, we have a ways to go here tonight. Can you work on that with Rob McGee? You spoke about that a while ago in the meeting.
Yeah, so there's just a number of provisions wherever the New York State Uniform Fire and Building Code or Albany City violations, or in one place it's referred to as the Uniform Code, not the Uniform Sustainability Development Code. We should be working on consistency.
We have 3 more speakers. Okay, going across on pictures here. Mike O'Brien again, then Tom Hoey, and Dan Awuso to wrap it up, I believe.
Okay, I gather from what Rob and Rick have said is that even though the ROP may have a lot more sensitive information in it, they are, as a routine practice, not going to require that be posted publicly, only basically a working contact number. And I don't know, does that have to be written into the statute, or is it, sufficient to trust that that's going to be the practice?
Yeah, I mean, the way it's written now, it does require the emergency contact name and phone number. But like Rick said, as a matter of department practice, he can post that on the back of the ROP, or, somehow feature it on that document so it's not particularly conspicuous.
Yeah, so there's not a tax ID or other, non-business contacts.
Correct.
And then my other question is, since this legislation will increase the frequency of ROPs and probably the overall number through better enforcement, will you have to increase staff, and that means increase expenses? And I thought there was an increase in fees, but if they haven't been raised in 9 years, maybe they need to be. And I don't know if that's a function that we have to do now, or I don't know. Are you going to need more inspectors to put this whole package of legislation into practice?
No, sir.
And you won't?
Nope. No, we'll have plenty, once we fill the 2 open positions we have, we'll have plenty to be able to handle that.
Okay, but don't you normally run a few vacant? Obviously, you're the guy who knows best, but if they haven't been raised in 9 years, maybe they need to be looked at.
Well, with leaving them at $50 and shortening the validity by 6 months, it is an actual slight increase, but not, as drastic as it had been stated it was.
Right, but it's also an increase in work too. I'll leave that up to your discretion.
Yep.
Those are my only points.
Thank you, Michael. Tom Hoey?
Yeah, I just had a point, and maybe Robert can address it. Right now, they were talking about with the ROP having the name of the owner of the building. Today I looked up on the tax records. I needed to find out who owned a certain building. Is there really a privacy concern if all the stuff is documented, you can go to the tax rolls and get the information. That's my question.
Yeah, I mean, I'm not sure that there is. I mean, I do appreciate kind of the peripheral concern there, but like I said, the landlord is going to be in a position to identify who the emergency contact is and what their contact information is going to be. So, there shouldn't be a surprise if that person gets a call. And that's why we crafted it in that way. We're not trying to like force the landlord to give like 6 points of contact or anything and post that publicly.
Okay, thank you. And that's what I was trying to say. I don't think there is a concern, but I just wanted to get that out. Thank you.
Thank you.
Bob, I have a concern. All this talk about posting the information, okay? They could post any place. They could post in their basement to fulfill the requirement. There's no.
Well, the language requires that they have to post it conspicuously.
Oh, it did say that? I didn't
Yeah,
read.
so it has to be like,
It's
in
not
an area that people
conspicuous
can
to me,
see.
I guess. Okay. What was it, Choco? Hey, and Mr. Hoey? Is Tom Hoey still there? I'm concerned about.
Yes, sir.
I'm concerned about Vince Raguso's picture on the. Vince, are you away? Okay?
What's the matter?
Oh, I saw Vince. It looked like he had passed out, maybe not.
No, he's okay.
Okay. Wusu, it's yours, and that's it, everybody. Wrap it up, Wusu. Oh, I like it this way.
Like my dad would say, Mr. Raguso's just resting his eyes. But anyway, just want to thank the sponsor of this resolution and also all the staff, and I strongly support it. And I want to thank the Commissioner, Rick LaJoy, for his suggestion as it relates to having the ROP in the front and the contact information in the back. So just want to put that out there and thank all the speakers.
Okay, so the last thing, I'm going to ask Danielle to set up another meeting on both of these proposed local laws, and we'll go from there. Okay, Danielle? I will see your hand still
Talk
up.
to you offline and find out some dates, okay?
Great. Do I have any motions to adjourn?
Motion to adjourn.
You're not on the committee, are you? Oh, you are. Sorry.
Second.
Okay, so we're adjourned.
Thank you, guys. Thank you.
Thanks, everyone. Have a good night.
Thank you all.
Thank everybody. Danielle, Jay.